request, my lords, may kindly post it on 10th, which is a physical day.
No, I don't know. Unless I hope.
This is LPA.
We will try.
So much obliged.
So much of postponing that.
I'm so sorry. Sorry, my lords.
May I mention one matter, my lords?
Yes.
It is from the roster of Honorable Division Bench number 1, my lords. Because today Honorable Division Bench number 1 is not available. It's a commercial appeal, my lords, arising out of the Trademarks Act, my lords.
We don't have the list of DB1. Wait for 15 minutes so that we get the list and the notice also. Then you make a mention in between.
My lords.
Malad, may I mention item number 48, Malad, from my lord's list?
Yes.
Malad, we have not been able to get the instruction as on today, Malad. I was praying for a simple passover for the day. So if it comes in the next week, Malad, I'll have the instructions, Malad.
Passover for the day. Yes. Any other adjournment prayer? 45.
Item number 49, Malad.
49 is for that beer matter.
Yes, Malad, in this case, Malad, I have already informed the petitioner, Malad, counsel for the petitioner, Malad. Malad, in this case, Malad, was addressing your lordship, Malad. Today he was not feeling well, Malad. Therefore, he has asked me to take adjournment for today, Malad. Actually, he was out of station for 3-4 days, Malad. Today he is having some problem, Malad. Therefore, Malad, in the morning only, I have been instructed, Malad, to take adjournment, Malad. I have already informed Mr. Neeraj Pandey, Neeraj Rai, Malad.
On the last date, both the sides had agreed to provide a compilation of parameteria provisions of different Excise Act and also Customs Act. So, have you provided that, Mr. Yadav? Petitioner has provided one Customs Act.
Yes,
Perhaps,
Malad. We have seen, Malad.
So, you haven't provided any such compilation. What do you say, Mr. Yadav?
Malad, we will provide, Malad. We will provide, Malad. I will have discussion, Malad. Today I am not in a position to, Malad.
You see, our office carries out all this due diligence to come prepared more or less when the matter is listed, and you make a promise 15 days back and still are not able to make a compilation with a battery of junior assisting to your offices.
I'm sorry, Your Lord, Malad.
Don't take us seriously, it seems. If you do not provide us good assistance, our judgment may become weak. Mr. Prabhat Tripathi, are you appearing in this matter, item 49?
Yes,
it appears that
yes, my lord. My lord, may keep this matter to the next Wednesday, 11th of May, if it is suitable for you, sir.
Then we'll simply pass over for the day.
Yes, Malad. Yes, Malad.
So the next date is, my lord, 11th May.
Wednesday.
Okay. Obliged.
Request for adjournment has been made by Mr. Ashok Kumar Yadav, GA1, since Learned Advocate General is not feeling well today. Stop. With consent of the other side. As prayed for, matter is passed over for the day. Be it noted that the
My lord, we have also filed a supplementary affidavit in this matter.
So please don't keep on filing affidavits one after the other without leave of the court.
My lord, last date, Your Honor had asked me to provide if there is any additional demand of duty as per the provisions of Section 28 of the Jharkhand Act.
My lord, that may not be indicated in the order. My lords had said that as per section, there is a differential duty that has to be paid when the goods leave the warehouse
Yes.
if prepayment is made. So
Okay,
probably
that way. Very well, but that compilation is missing from your side, Mr. Mittal and Madhav, and there is only one act, Customs Act provided by the petitioner.
yes, my lords, because my lords we've
Yes,
prepared a compilation. My lords, we'll send it by the next date, my lord, of the acts and rules.
very well. Last word for the day.
Minutes,
Item, which item, Mr. Pasari?
minutes, wrongly we referred it as 47. It ought to be 46 minutes.
It's 46. It is 46.
Yes, 40.
Why do you want an adjournment?
Because minutes, the matter is now remanded by the ITAT to the Learned Commissioner of Income Tax Appeals. And I am informed that Commissioner of Income Tax Appeals is now sitting at Jamshedpur and taking up the matters. So ultimately, if the demand is set aside as against the company, my writ becomes infructuous. So that is why I wanted that this matter may come up in the reopening week after summer vacations.
Item 46. Mr. Nitin Kumar Pasari states on seeks praise that the matter may come up after reopening of summer vacation 2022, as according to instructions, the ITAT has remanded the matter to the learned CIT appeals
Yes,
during
minutes.
pendency. During pendency.
Yes, minutes. During pendency minutes.
During pendency of this writ petition. So the fate of the remand matter, no, the fate of this writ petition may depend upon the order passed in remand by the CIT appeals.
Absolutely, minutes.
As
Absolutely.
prayed for, this is the case after reopening of summer vacation 2022.
One matter at
Manoj, my appearance for respondents.
Already recorded.
Much obliged.
Subject.
one matter, Malad, serial number 45, Malad.
Yes, yes.
Malad, in this matter, Malad, our file is not traceable. That is why, Malad, I could not.
Miss Amrita is perhaps something.
No, 45, Malad. I am asking.
No, 45.
45.
So, make it 45. This is again that Tran 1 something.
Malad, our file itself, I am not aware what is the matter, in fact.
Wait, Tran 1.
Okay, Malad. Let it be immediately after vacation, Malad.
As prayed for by learned counsel for the petitioner, with consent of the other side. Let the matter be listed after vacation. Summer vacation 2020.
Let's subject to Mile's permission. Let's serial number 53. Yesterday late in the evening, Mr. Rahul Sabu had called and he informed that he is unwell and probably he has circulated a letter also.
Yes, there is a request from some side.
So, Manoj, I would request let the matter remain in the list, Manoj, for the next week.
Request for item 53, a request for adjournment has been made by learned counsel for the respondent state, Mr. Rahul Sabu, on the ground of his illness, with copy to the other side. No, for which an email has also been circulated with copy to the circulated. Learned counsel, Mr. Nitin Kumar Pasari, prays that the matter may be simply passed over for the day. Accordingly, let the matter be passed over for the day.
Manoj, the interim order is still today, Manoj.
Interim order dated so and so shall continue till the next date.
Much obliged, much obliged.
Yes. On Let us take up the list.
From the daily causes, under the heading for orders with defect, item 1, WPT number 1045 of 2022, along with item number 2, Mr. Piyush Poddar for the petitioner, Mr. Sachin Kumar, Mr. Sukumar Yadav for the response.
Lordship, I'm for the petitioner in this matter, Lordship.
Just tell me.
Lordship, all defects have been removed, Lordship, in this matter.
No, no. What is this last report? 7th March 22. So there are few defects still remaining as per the office note of 30th April 2022.
But I have removed all the defects, so I'll verify what the defect left after. It may come next Monday, Lordship. There's urgency, some urgency. The demand notice has been issued, Lordship, in this matter.
95 not removed properly. Sprint not removed properly. Learned counsel for the petitioner submits that all the surviving defects were removed pursuant to the order dated 21st March 2022. In both the writ petitions,
Yes, Lordship.
so, however, it appears that office has noticed certain defects which have not been properly removed. Stop. Then counsel for the petitioner, Ms. Rakhi Sharma, undertakes to inspect the records and remove it by Saturday.
By Friday, Lordship, I'll remove all defects.
We give you still Saturday.
Yes, Lordship.
The defects are removed, the matter will be listed in the next week as prayed for my learned counsel for the petitioner under appropriate schedule. Let the defects as pointed out by the office be indicated in today's order.
So bless you.
For orders, item 3, first appeal number 351 of 2017, Mr. Lupesh Kumar for the appellant, Mr. Pandey for the respondent.
We are appealing for the respondent number 123. We have filed counter affidavit to the IE petition filed by the so I am praying that the matter may come after vacation for hearing on the IE.
Reply to the interim to the IA number 2482 of 2021 seeking interim custody of the minor children has been filed by the respondents, Stopland Council for the senior council submits that the matter may come up after summer vacation 2022. So since the council for this petitioner is appellant is also not present today, let the matter appear after summer vacation.
Item 4, WPT number 5730 of 2017, Mr. Sumit Garudia for the petitioner, Mr. Rajesh Kumar for the respondent.
Well, it has come on my interlocutory application. It was filed in 2019 itself.
Who is appearing for the respondent?
Probably of Mr. Rajesh Kumar. He has since been elevated to the bench, my lord. His name is.
So perhaps no one would be appearing today.
Yes.
What is the urgency?
Lord, it is no urgency, my lord. I can give the fresh copy of the brief to the office of the Advocate General.
Very well. Mr. Sumit Grodiyal and counsel for the petitioner is present. Stop. So it may come under admission because
Yes,
otherwise
admission,
it
my lord. Yes.
has a it appears that the erstwhile state council has since Mr. Rajesh Kumar has since been elevated to the bench. Stop. No other state council's name is reflected in the cause list. Then counsel for the petitioner undertakes to supply a copy of the pleadings upon office of the learned advocate general so that the brief may be allotted to state council. Stop. So that the state is represented on the next date. Stop. Receipt of service of copy be filed by Friday so that the name of the learned state council is reflected in the cause list also. And thereafter, in place of the erstwhile council. Matter be listed after summer vacation 2022. And after reopening of summer vacation. Under admission.
Item 5, first appeal number 377 of 2018, Mr. Sandeep Verma, Mr. Kisle Prasad for the appeal.
May I please, my lord? My lord's direction, my lord, we have taken steps for substituted service of notice upon respondent, my lord, and notices has been published, my lord. Page number relevant is page number 5 and 7, my lord.
Okay.
So,
Now it has been issued in correct name.
yes, my lord. The correct name, my lord, Gaurav Raj, my lord. Correct name.
Mr. Sandeep Verma
Page
for
5
appeal.
and subsequently page 7 also, my lord.
In support of the proof of service of notice upon the respondent through paper publication, the extract of the newspapers have been annexed. Two newspapers have been annexed. Prabhat Khabar and Dainik Bhaskar have been annexed at Annexure 1 to supplementary affidavit dated 27th April 2022. Therefore, service is treated as valid. Admit
Deeply
call
obliged,
for the
my lord.
court records in connection with so and so from the court of so and so. Your suit was dismissed.
Yes, yes, my lord. My suit for dissolution of marriage has been dismissed, my lord. From Ranchi, my lord. Family court, Ranchi.
Admit call for lower court records in connection with so and so from the court of so and so. Place the matter under the heading to hearing as per it says on the seat of LC.
Much obliged, my lord.
बढ़िया लिखे हुए हैं 26 घंटा उसमें आर्गुमेंट हुआ है.
Item 6, first appeal number 280 of 2019, Mr. Anurag Kashyap for the appellant, Mr. Ritesh
May I
Kumar
please
for the.
approach in this case?
Yes.
Yes, Your Lordship. On the last day, the order that report was called from the lower court for the proper execution of the maintenance case, Your Lordship.
Yes.
Now we have taken instruction and we have persuaded the case and we have talked with the client, Your Lordship. He is willing to settle the matter and he is willing to pay 3 lakh rupees as a one-time settlement, Your Lordship. As he is a para teacher and he is earning 12,000 per month, so he is facing hardship and he will sell his land and he will pay the rupees, Your Lordship. We have insisted that to enhance the amount, so at last he has come to that if the other side is willing to settle the one-time settlement, then he will ready to pay rupees 3 lakh rupees.
There is a status report also.
Yes.
The letter was secretary for providing legal aid. Complied. Kumar has been lifted conduct. He is suited on Mr. Ritesh Kumar, your client also wants this settlement through mediation.
Lordship, she also wants settlement.
Earlier, the parties had gone or what?
Yes, Lordship. Earlier they were going to Khalsa and the appellant was agreed to pay 10,000 rupees, so mediation was failed.
So, Mr. Suraj Kishore, you want to go for mediation, your client wants to go for mediation only to
Yes, Your Lordship. Let
get
it be referred to the Jhalsa, Your
areas
Lordship.
of maintenance compromised, or is there any real intent to settle the matter?
Lordship, as he has instructed, and we have persuaded a matter, and we have tried to convince him that he has to pay. So at last he is willing to
So,
settle the matter.
to show his bona fide, pay 1,50,000 in one installment at the
Your
first
Lord,
instance.
Your Lordship, I will seek instruction with regard to time, Your Lordship.
No, otherwise the learned family court has directed to the
Yes, Your Lordship, yes, Your Lordship. So as far as I have to take instruction with that at what time he will going to pay, because he have to sell his land, Your Lordship. That's why. The only difficulty is to give him that first he have to sell his land. Thereafter he will pay the amount, Your Lordship. Because he is working as a para teacher and he is earning just rupees 12,000 per month, Your Lordship.
very well, Mr. Kishore. Next Wednesday, you submit your
Yes, Your Lordship.
response after taking instructions.
Yes, Your Lordship.
Status report has been received from the learned family court, Umla, by letter number 108 dated 30th April 2022. Stop. The respondent wife has been granted legal aid, has been given legal aid in the civil miscellaneous case number 2 of 2022 for execution of maintenance decree in her favor. Filed for execution of maintenance decree in her favor. Stop. The maintenance amount as per till March 2022 is from October 2015 till March 2022 is in arrears of rupees 3,90,000. Stop. Since the opposite party husband did not turn up before the court on the date fixed, that is 30th April 2022, the District Education Officer Gumla has been directed to make deduction of the maintenance amount at the rate of rupees 5,000 per month from the arrears of his salary. Stop. He is presently working as para teacher at Nagfeni, Gumla. Stop. Counsel for the appellant submits that the appellant is again inclined to settle the matter amicably through mediation. Stop. On being asked, then counsel for the appellant submits that he would seek instruction whether the appellant is willing to pay, ready and willing to pay the arrears of installment, arrears of maintenance in installments, arrears as a first step, whether the appellant is willing to pay the part of the arrears of maintenance that is rupees 1 lakh. 1 lakh as first installment to show his bona fides. Stop. Let the matter be listed on next Wednesday. Mr. Ritesh Kumar for the respondent.
Obliged.
Obliged.
Item 7, first appeal number 70 of 2020, Mr. Asutosh Anand for the appellant, Mr. Sanjay Kumar Pandey for the respondent.
I am appearing as the respondent in this case, my lord.
Mediation has failed.
My lord, mediation has failed, my lord. But when it comes in the knowledge of the appellant, my lord, that replace warrant has been issued against whom in the maintenance case, my lord, he had taken his wife to his house, my lord, and left his house, wife in his house and went to this Delhi, my lord. Now the respondent is residing in the matrimonial house, my lord. When it's come in the knowledge of the appellant that distress warrant has been issued and he had taken the house outside from the Jharkhand and left the respondent in his house and went to Delhi, my lord. Distress warrant has been issued on 27/27/2019 in maintenance case number 55 of 2010, my lord. Right now,
So
1,36,000 due.
both the parties are living happily now.
No, my lord, he is playing a game, my lord. He has taken the wife in his house when it's come in the distress warrant has been issued. After staying one day, my lord, he went to Delhi.
Why did the wife go back?
The wife has because he has stated that I will keep her in his house, my lord. उसको समझाया उल्टा पुल्टा और ले गया घर में और छोड़ के चला गया दिल्ली.
They are playing a game of hide and seek like children. We will admit and call for the lower court records. Let the family court take steps towards execution of the areas of maintenance.
My lord, already distress warrant has been issued. 82 has been issued, my lord.
Mediation has failed as per the report of learned mediator Jhalsa, bearing letter number 1299 dated 30th April 2022. Admit call for the lower court records in connection with so and so from the court of souls. Place the case under hearing for hearing on receipt of LCR as per its age. Vineet Chandra for appellant, Mr. Sanjay Pandey for respondent.
Item 8, WPT number 2018 of 2020, along with item number 9 to 12, Mr. Sumit Garudia for the
The operative part of the judgment reads as under. Accordingly, we hold and declare that petitioner is entitled to the benefit of exemption from payment of electricity duty under the Bihar Electricity Duty Act 1948 in respect of its 30 megawatt of captive power generation plant having date of commercial production on 4th May 2009 in terms of the provisions contained under clause 15.2.2 of the Jharkhand Industrial Policy 2001. Consequently, we quash and set aside the orders all dated 29 January 2020 passed by Commercial Taxes Tribunal, Ranchi in revision number so and so for the periods 2009-10, 2010-11, 2011-12, 2012-13 and 2013-14 respectively. We remand the matter back to respondent number 3, Deputy Commissioner of Commercial Taxes, Aditpur Circle, Jamshedpur, to pass fresh assessment orders extending the benefit of exemption from payment of electricity duty in respect of 30 megawatt CPP to the petitioner and to issue consequential excess demand notices of the amount of electricity duty realized, if any, from the petitioner in respect of its 30 megawatt CPP. With the aforesaid directions, all these petitions applications stand allowed and disposed of.
Obliged, my lord.
Oblige, Your Lordship.
Pending IA closed. IA closed.
Item 13, first appeal number 40 of 2021, along with item 14, Mr. Avin Kumar, Mr. Atit Kumar Sekhar, or the appellant and respondent.
Yes, who appears?
For the appellant in the item number 14, for the respondent, item number 30. For the wife. In this case, the next date fixed in the Jharkhand is 14th May.
Acha, then extension of time.
From last date, notified directed
Request for extension of time. Request for extension of time has been received.
Your Lordship, for
Yes.
serial number 13, Your Lordship, possible for few cases, Your Lordship.
The mediator has sought extension of time, so we will extend it for some time.
Lordship, in this case, on last occasion, Lordship had directed the husband to file an affidavit in the last para of the order, Lordship. Last date. Order dated 10/3/2022. Last para. In last 40 months, they are not paying the maintenance, Lordship. The area is 7,10,000 a year. They had only paid 10,000 during that period.
Has he filed an affidavit?
No, Lord. No affidavit was filed. Neither they are paying any maintenance from last 40 months.
So somebody was praying for a Passover on behalf of Mr. Arvind Kumar.
Only Arvind Kumar has joined the office now.
Anyway, today we will extend the time and ask them to file affidavit. Request for extension of time has been made by learned mediator Jalsa in letter number 1111 dated 16th April 2022. Since mediation is underway, stop the next date before the learned mediator is 18th May 2022. In view of the request made by learned mediator, time for concluding mediation is extended by 4 weeks from today. The matter be listed along with the after the opening of summer vacation 2022. So it appears that the husband has not filed any affidavit regarding proof of maintenance of payment of maintenance amount as per the intent of the order dated 10th March 2022. Stop. Let such affidavit be filed on by the next date.
Item 15, WPT number 872 of 2022. Mr. Prem Mardi for the.
Your Lordship, I am appearing in this case, Your Lordship.
Yes.
As Your Lordship, one defect was to be ignored. I have filed the IA 3621 for ignoring the defect because respondent number 7 retainer counsel for respondent number 7, which is Goods and Service Tax Network.
I will accept, my lord. I appear for GSTN, my lord, as well. I will accept notice.
Mr. PSPT accepts notice for responding number 7, Goods and Services Tax Network. Stop. As such, prayer made for ignoring the defect relating to service of notice on respondent number 7 made through I number 3631 of 22 is disposed of as infructuous. Let copy of the pleadings be served upon Mr. P.S. Pati and counsel for respondent GSTN by Friday and receipt thereof to file. Matter be listed under appropriate heading.
Millets for respondent number 1 and 2 millets.
1 and 2, what?
Millets, Union of India, Ministry of Finance is also a party because they made union of.
Let the name of Mr. AGI, Shan Pallav, appear. Acha, his name is already appearing.
Yes, millets. Appearance millets may be recorded. Because there's one preliminary objection, millets.
That we will consider when the matter is under admission.
Obliged, millet.
Obliged, my lords.
Chalan, AC to ASGI.
Admission. Item 16, WPT number 2108 of 2019, along with item number 72 to 37, Mr. Anand Kumar Sinha, Mr. Vikas Pandey for the petition.
No affidavit has been filed after that previous order of 14 December 21, except in one matter, which is item 30, WPT 2714 of 20. But that's on a different thing that the petitioner had not submitted proof of GST deposit within 15 days. So state respondents, why have you not filed any affidavit?
But the affidavit is not filed in my lord.
None of the cases. None of it. Except one where I have said that they are only, the executive engineer is taking a plea that proof of that GST deposit has not been filed for the relevant period within 15 days. A whole lot of matters are stuck up because of this issue of reimbursement of GST paid in ongoing contract. Yeah, I missed You are the counsel for petitioners. Nobody is saying anything.
My lord, pursuant to last order of lordship, I have applied my lord's
There is a lot of Mr. Sumit Garodia, Mr.
Serial number 30 and 37
Sinha,
are
Mr.
Yes, Milord. I am appearing serial number 32, Milord. On the last occasion, my lord was directed the state to file the application regarding the formula they adopt for the matter, Milord, for differential amount of tax, Milord.
One at a time. One at a time. One at a time. Yes, Mr. Deepak Sinha, what are you saying?
Yes, my lord. On the last occasion, my lord has directed the state to file to formulate a formula for solving the entire matter, my lord, regarding that differential amount of tax, my lord, and they have not filed the same till date, my lord. That is the
Yes, Mr. Pasari, you are also there in these matters.
Serial number 33 to 36 minutes. I had mentioned it, and that is why it has come on board. Minutes. The order was passed on 15th of February for filing of counter affidavit by the licensee as also the state. Minute, it has not come. Now, minutes. The situation is such that more than 150 crores have been stuck. Our working capital is virtually blocked. And neither the licensee is interested nor even the state is interested to take a call as to how do they want to reimburse it or they do not want to reimburse it.
Licensee in your case means?
Jharkhand State Electricity, Jharkhand Bijli Vitran Nigam Limited. We have concluded the contract. We have handed over the entire assets. Now, this is the state of affairs. We do not know how to go
There
about
are
things.
different departments involved.
Yes, Manoj.
Concerning the same issue.
Yes, Manoj.
But may I suggest something, sir, due to your lordship's kind consideration?
Yes.
But the circular which has been issued by the Commercial Taxes Department, that is the secretary, my lord, which has issued the guideline, and there are various departments involved, my lord, in all these matters. If your lordship, because they are not responding, my lord, individual departments are also not responding. Subject to your lordship's pleasure, if the chief secretary or the secretary of the Commercial Taxes Department, my lord, they are been made as a nodal thing to at least proceed with the matter. I was even suggesting for a disposal of the writ petitions, but the manner in which they are keeping it pending, it will all again lead to contempt and other proceedings with no decision with the respondents. Because the matters are multiplying day by day. So if your lordships can draw the attention of the chief justice, chief secretary, and or the secretary of the on the pending matters.
Where are the state councils?
Yes, my lord, I am appearing.
What is the state of affair? No
The
response.
counter has not been filed, my lord, but what I have been informed, my lord, that some exercise is being taken by the authorities, my lord, to sort out this this problem, my lord. So the matters have been listed, my lord. We have not filed the affidavit, but that is there, my lord.
The state has worked out a mechanism and they should implement that mechanism on their own. Otherwise, court may unnecessarily be invited to issue directions in a field which is of some calculation, computation involving experts of charter accountant and departmental finance officer, whatever you call it, accounts officer.
Yes, my lord.
Actually,
My lord, with kind permission of my lords.
If you also permit me, my lord,
yes.
there is no doubt that the affidavit has not been filed. But your lords, I will pray, my lord, at 2 weeks' time will be granted, my lord, even by way of last chance, my lord. We will, my lord, make take all endeavor, my lord, to comply the order, my lord.
The problem is of a mindset. Actually, the departments do not want to to reimburse things. They only want to collect. And they don't realize that if the business comes to a standstill because of this, what you call,
My lord, may I submit, my lord? My lord, may I
one-sided
submit?
approach, then the revenue will also not come back or be cut. One of the group of petitioners are saying that 150 crores paid as GST waiting for reimbursement. There might be many such petitioners concerning different departments.
Yes, Lord. Then
You suggest what should we call the secretaries to take a call, secretaries of all the concerned departments to appear and decide amongst themselves that who will be the nodal officer to deal with such issues.
Your Lordship can, my Lord, maybe Lord, as suggested by my learned friend, my Lord. There will be no harm if your Lordship indicate, my Lord, in the order, and then let the Chief Secretary take a decision in this regard. Who will be the nodal officer? Or, my Lord, at this stage, my Lord, I will request, my Lord, my prayer would be, my Lord, that 2 weeks time will be granted. I will try, my Lord, I will follow with them, my Lord, the issue. I will try to resolve, get it resolved, my Lord, at the earliest.
My lord, in one case, my lord, in one case, counter affidavit has been filed, my lord. That some portion of that calculation part is missing from the counter affidavit also. Therefore, that is also not complete, my lord.
Reference may be made to the order dated 14 December 2021 in the batch cases led by WPT 2108 of 2019 and certain other cases starting from which serial, Mr. Pasari?
Wants to know.
Now all have been
serial?
followed by
And
respective.
so other cases which have been tagged later on, wherein also by order dated 15 February 2022, respondents were asked to file counter affidavit. No counter affidavit has been filed except in WPT number 2714 of 2020 after the previous order, though that affidavit is not in the context of the order dated 14 December 2021. Stop. Concerned department, the petitioner's grievance relates to different departments. The case of the grievance of individual petitioners relate to different departments, but the issue is common. That is reimbursement of the differential tax of GST paid by the petitioners in subsisting contracts. यही ना है, Shagrudia?
Subsisting and or well, the contracts which have already been executed.
Executed before 1st July 17?
Even before 1st July 17 also, my lord. No, not before 1st July. Contracts subsisting and or executed after 1st July 17, my lord.
Or contracts executed even after 2017 upon implementation of the GST regime. Stop. Since the order dated 14 December 2021 refers to the SOP framed by the MORTH through letter dated 19 December 2018, by which a framework by which a mechanism was framed and also the letter dated 14 July 2021 issued by the Secretary Commercial Taxes Department Government of Jharkhand bearing letter number 1421. The problem lies in its implementation only as it appears. Stop. It is also it also shows that different departments need to implement the SOP in a uniform manner so that agencies / contractors so that the grievances of the petitioners are concerning different departments are redressed on uniform principles. Stop. It appears that lack of coordination amongst different departments of the state may be one reason for not giving a concerted response to the order dated 14 December 2021. Stop. We therefore feel that the matter be brought to the notice of the Chief Secretary Jharkhand so that the issue at hand may be addressed through a nodal department and guidelines or a framework for its implementation may be laid down or its implementation with a time frame may be laid down. Stop. Learned AG 2, Mr. Sachin Kumar and other state councils are at a loss for not being able to file the affidavits in the respective petitions pursuant to the order dated 14 December 2021. इसको ऊपर में कर दीजिएगा जहाँ GST का जहाँ लिखेंगे. As such, last में लिखिए, उसमें ऊपर में ही लिखिए. Learned state councils have prayed for further 2 weeks time. Stop. However, while adjourning the matter for 4 weeks, we request the Chief Secretary Jharkhand to look into the matter and see that proper guidelines are laid down for redressal of the grievances, for addressing this issue in a time-bound manner concerning different persons / petitioners Stop. This the case in the second week. These cases in the second week after the opening of summer vacation 2022. Let a copy of the order dated 14 December 2021 and the instant order be sent to the Chief Secretary Jharkhand to fax and email.
Much obliged, my lord.
Much obliged, my lord. Much obliged. My lord, if possible, any date may be fixed, my lord, in the
Second week.
obliged. Much obliged.
Item 47. WPT number 2. Sorry.
38.
Item 38. First appeal number 89 of 2020. Mrs. Nita Krishna for the appellant. Mr. Kripa Shankar Nanda for the respondent.
Yes, who appeared?
Yes, Your Lordship, I am appearing on behalf of Your Lordship, appellant, Your Lordship. They have arrived at a settlement, Your Lordship, in Jhalsa, Your Lordship. And the appellant was supposed to pay 80,000. That has already been, he has ready to pay, and they have agreed to file a mutual divorce. And the date was fixed for filing the divorce was 24th of April, Your Lordship. But she couldn't come up from West Bengal. So the day she has given the date on 25th May, she will file the mutual petition for dissolution of marriage.
Mr. Kripa Shankar Nanda. Mr. Nanda. Mr. Krishna Kumar. Then counsel for the appellant submits that since the respondent did not turn up on for filing of the suit for divorce through mutual consent on 24th was a Sunday.
25th को filing होनी थी, Your Lordship. They were supposed to file
April 2022. In terms of the settlement, the amount of alimony of rupees 80,000 could not be handed over to her, nor could the suit be filed. Stop. She has, however, indicated that she would be she would remain present on 25th May 2022 for the same purpose before the Learned Family Court, East Singhum, Jamshedpur. Stop. No one appears for the respondent today. As such, let the matter appear in the reopening week after summer vacation 2022 for the parties to show that the terms of settlement have been complied with and this appeal can be disposed of in those terms.
obliged, Your Lordship.
Item 39. WPT number 840 of 2020 along with item number 40 to 44. Okay.
Yes, my lord. This Vitran Nigam Limited has not filed any counter affidavit.
Yes. Yes, my lord. They took time for 3 weeks for filing counter, but till date they have not filed. By the order dated 7/2/2022.
Where is Mr. M.K. Roy? Just a minute. Mr. Kripa Shankar Nanda,
Yes, my lord, I am appearing, my lord.
your case has been adjourned to first week after the opening, since
Yes, my
perhaps
lord.
your did not turn up to file
Yes, my
at
lord,
the
I could not connect myself, my lord, due to some error in my.
No, your client has assured that she will appear on 25th May 2022.
Yes, my lord. My lord, on last occasion, appellant has given wrong date, my lord. It was earlier fixed for 29th May. She has given wrong date about 29th April. It was 29th 5. That is why this case has been posted in this week. Anyway, my lord, it is correct, my lord. I will, no problem.
29th में है या 25th में है?
29th हमको तो बोला गया है।
आप लोग दोनों पूछ करके कोर्ट मास्टर को बता दीजिए ताकि सही डेट लिखा है।
ठीक है, हम बता देंगे, तिवारी जी को हम बता देंगे।
Very well. In these batch cases, where is Mr. M.K. Roy?
All right. Okay. His name is also appearing in the cause list, my lord.
He appeared on the last date.
Yes, my lord, on 7/2/2022, order sheet number 7.
Council was appearing at that time. Mr. Deepak Sinha, you inform Mr. M.K. Roy.
I've informed him, my lord. It may pass over for 2-3 cases, my lord.
very well pass over for two cases. ये जरा 52 को सॉल्व कर लीजिए तो इसमें भी टाइम होगा.
Item 52, WPT number 215 of 2022. Mr. Pratyush Kumar Jha for the petitioner, Mr. Rajiv Sinha, Mr. Abhit Kumar for the rest.
Mr. Amit Kumar, you have not filed counter affidavit in this.
Your Lordship, in this counter affidavit has not been filed.
So therefore we took it up out of turn because he would be asking for time. No counter affidavit has been filed. Anyone appearing in item 52?
My lords, I am there for the petitioner, my lords.
So counter has not been filed. We want to know from the CGST council as to how and when will he file the counter.
Your Lordship, no one is appearing for the respondent. All are for the petitioners.
My lord, Mr. Amit Kumar is appearing in this case. I will inform him, my lord. It is passed for one case. I will inform him to join.
He was allowed 4 weeks time earlier. On 8th of March 22, he was allowed 4 weeks time and 2 weeks for petitioner to reply. Now it has been listed in May. Grant him 3 weeks, tell him to file positively.
My lord, I will.
The counter affidavit has been filed by the CGST despite 4 weeks time granted by order dated 8th March 2022. Stop. However, by way of one more indulgence, further 3 weeks time is allowed to do so, failing which suitable cost may be imposed on the next date. Matter be listed after 4 weeks so that petitioner if so advised may file reply thereto in the meantime.
Oblige, my lords.
Yes, now item 47.
Item 47, WPT number 2404 of 2020, Ms. Amrita Sinha for the petitioner, Mr. Rajiv Ranjan, Mr. P.S. Patil for the petitioner.
May I please, Your Lordship?
Yes.
I have supplied the compilation, Your Lordship, in this matter.
Yes. Just to satisfy our inquisitiveness,
Yes, sir.
are you aware of such matters which are concerning transition of tax deducted at source of value added tax?
Tax deduct. No, Your Lordship.
Other matters, similar matters, my lord, you are saying.
Yes.
My lord, one of the departmental officer told me that they have done this in other cases as well, and those orders have been challenged, but he could not provide me the case number. I can find it out, my lord. He has told me that similar instances have happened in other divisions as well, where the TDS was taken as a transitional credit, and later on they have, in similar manner, they have rejected it and passed similar orders. I have been told by him.
In one case of Mr. Garudia, if I am not mistaken.
That's Bhilai Steel Plants, my lord. Bhilai Steel Plant. That's a Bhilai Steel Plant matter, my lord.
VAT assessment authorities actually treated it as being carried over. The GST authorities denied it. So there were two orders, perhaps on the last date Mr. Garudia pointed out, and then we asked the department.
Even in the case in hand, Your Lordship, this is the same situation. In VAT audit, they have treated under GST, and in GST, they are saying that they have rejected it. Even in this particular matter, also, this is the same situation.
So, Mr. Garodia, when is that matter?
It is listed tomorrow, my lord, and your lordship had directed the officers to be present in that matter.
So, Mr. Pati, you are appearing, or Mr. Mittal, you are appearing?
Lord, Mr. Yadav is appearing, my lords, in this matter.
No, in this matter?
In this case, I am appearing, my lords, item number 47, which is listed today,
So
my
you
lord.
you are appearing for whom? GST,
My lord, for the
Mr.
state, my lord.
Okay.
GST.
So then the situation becomes same in both.
Yes, Your Lordship. I have also annexed that assessment order of this particular year, wherein they have treated it under GST.
Should we keep it tomorrow so that there is no dichotomy in the stand of the commercial taxes department, and GST obviously has the same stand.
As Your Lordship.
Yes, my lord, it may come tomorrow, my lord.
Which is that matter, Mr. Garodia? Item serial number?
Yes.
Sorry, writ petition number.
WPT 1429 of 2021. Messrs. Bhilai Engineering Corporation Limited. It's listed at serial number 31 tomorrow, my lord.
Okay. So, Mr. Pati, you can be ready with your instruction from the concerned officials if they are common. Which is the circle in this case, Ms. Amrita, and which is that in Mr. Gorodia's case?
Mine is Dhanbad, my lord.
It's in my case.
Urban Circle, Dhanbad. Urban Dhanbad.
I think mine is also Dhanbad only, my lord. I don't remember the circle, but I think it would be the common circle most likely, my lord.
Very well, then tomorrow we will have a common view with identical matters from the respondents. Since similar issues, since writ petition WPT 1429 of 2021 involving similar issue is posted tomorrow, let the instant case be also posted tomorrow.
Your Lordship, I hope the paper book is with before Your Lordship. I have filed it in the hard copy itself.
Yes, yes. There is paper books. Basically, you are relying upon that Madras judgment.
But there are Madras judgment, Telangana judgment on which I am relying upon, and on the other issue I am also relying upon the Patna High Court judgment so far as interest penalty is concerned.
Patna judgment is of June 2019. Madras judgment is of
2021. Madras High Court judgment is squarely covered with this particular matter, Your Lordship. I am not on the point whether the TDS will be same as will be amounting to ITC, but I am on the point that under section 140 the TDS can also be carried forward and transited under section 140.
We had heard you last year at length, but then the second wave of COVID came perhaps.
Pre-COVID, my lord. I remember, my lord. I took adjournment that time. I was having fever. I remember it was in the first week of April. This case was taken up, and thereafter immediately I was detected for COVID positive. This was heard twice or thrice, my lord, at length by your lordships.
But on that occasion, Your Lordship, I was there with the TDS be treated as ITC. But now that I am not on emphasizing whether the TDS will be treated equivalent to ITC, but 140 cover, it's a wider scope and cover itself. And there are other arguments also, Your Lordship, which I will be placing before.
And, why are the respondents opposing it? Simply on the TDS not being treated as ITC or on a larger?
Yes, simply that TDS not treated as ITC, simply on this point itself. They are not even denying that the TDS amount was there or something.
And you are not in a position to get the refund of the TDS then?
Neither I am getting refund nor I am getting VAT adjustment, neither I am getting to be allowed in transition of under GST, Your Lordship.
So, unjust enrichment.
And plus, they are also charging interest and penalty on the same amount.
Very well, tomorrow.
Obliged.
Obliged, madam. Madam, my appearance may kindly verify.
It's the PS Pati for the state.
State.
Obliged, Your Lordship.
Yes.
Item 50, WPT number 1458 of 2021, Mr. Nitish Kumar Prasadi for the petitioner, Mr. Ashok Kumar Yadav for the respondent.
If it may please your lordship.
Yes.
Your lordship, in this matter, pleadings are complete. I was praying that this matter may be taken up in physical court.
20%. The only issue is that whether 20% involves the interest also, penalty also, or only tax.
That also, and your lordship, the leviability of penalty under section 40 of the JWAT Act.
Well, in this case, penalty and tax both have been imposed. So 20% of the tax would have to be deposited, even if their argument is that 20% of the penalty does not have to be deposited. And they have deposited it at the tribunal stage. So it's a simple case. It could go back to the appellate authority.
That is what, while going things, I also found out. List So, Mr. Mittal, according to you, it can be remanded on the issue that 20% of the tax amount stands deposited, whether it is leviable under section 40, 20% or not. On penalty, for that the tribunal may decide it.
Yes, my lords, because 20% of the tax amount has been deposited.
Look, so there was a
25, sorry.
Because there was a direction to deposit 25% of the tax assessed, we have deposited it, pursuant to the orders of the learned tribunal. Now, if my lords would go through the appellate, the provisions under the VAT Act, this says that tax assessed 20% to maintain an appeal. Penalty or interest cannot form part of it, which I have deposited, so it has to go. Now there cannot be a rider against me that I have to again deposit 20%. That is where the tribunal has gone wrong.
So there is no issue of question of remand according to you.
Actually, if my lords would see the order which has been passed by the tribunal.
Yes.
At page 92.
Yes.
Paragraph 32 I am referring to, 32 onwards.
92.
Page 92 minutes. It's a part of the tribunal's order.
Right. 32 onwards. Yes.
Thus, in view of the discussions made above, we find no merit in this application, such and such dismissed. However, the petitioner will be at liberty to move before the learned appellate court by depositing 20% of the assessed tax, and if the petitioner deposits 20% of the assessed tax, then the appellate court shall further proceed. Now the question, if I have already deposited 25%, there was no necessity of this rider.
Why have you come before this court?
Well, it's because 25% I deposited as an interim order. Now again 20% I have been directed to deposit.
My lord, I'll just intervene for 1 second, because the tribunal has noted that there is nothing on record to show that 25% has been deposited.
Well, that's how my learned friend is saying. That.
I'm just explaining what the tribunal has said. I agree that there's a challan on record. The reason why
challan was before the tribunal as well.
I'm not disputing that. I'm only saying that.
How the petitioner will get liberty to move before the appellate court by depositing 20% of assessed tax, and
if the petitioner deposit the assist of the appellate court shall proceed further in accordance with law, shall dispose of the appeal. Appeal pending.
डिपॉजिट के एब्सेंस में सिर्फ अपील डिसमिस हुआ था. The appeal was dismissed by the
Minutes on the
joint
20%
commission
issue.
only on 20% issue.
Yes, Manoj. If Manoj would see page 61,
So
what's the appellate order?
61. Yes.
Minutes last paragraph I'm reading. I'm reading. It's a very small order. मुख्यालय झारखंड राज्य के द्वारा सूचना दी गई उक्त फर्म के द्वारा छद्म सी फॉर्म उपयोग किया गया है, जिसके आधार पर उपर्युक्त प्रतिष्ठान के प्रांतीय वर्ष सचन सच का मूल कर निर्धारण आदेश हजारीबाग अवर न्यायालय के द्वारा पारित किया गया, जिससे क्षुब्ध होकर अपीलार्थी द्वारा अपील वाद दायर किया गया. अपीलार्थी के द्वारा 79(3) के अंतर्गत प्रविष्टि हेतु अपील दायर किया गया है. अधिवक्ता दिनांक सचन सच को सुनवाई हेतु उपस्थित हुए. अधिवक्ता द्वारा तर्क प्रस्तुत किया गया कि इनकी अपील ससमय दायर किया गया है एवं 20% की देयता नहीं बनती है. 20% के बचाव में सचन सच के मामले में माननीय उच्चतम न्यायालय के न्याय निर्णय का हवाला दिया गया. उक्त तथ्यों के आधार पर अपील को स्वीकृत करने का आग्रह किया गया. अपीलार्थी के बयानों को दर्ज किया गया. दर्ज बयान एवं सुनवाई के समय वह सचन सच स्वीकृत कर एवं इसके जमा के बिंदु पर जिरह किया गया तो कोई संतोषजनक जवाब नहीं दिया जा सका. विवादास्पद राशि में सन्निहित कर की राशि 5 लाख सचन सच के जमा के जिरह पर तर्क दिया गया कि बोगस आंकड़े के आधार पर कर आरोपण किया गया है, अतः किसी प्रकार के कर एवं शास्ति का भुगतान नहीं किया जाएगा. प्रस्तुत बयान संतोषजनक नहीं पाया गया तथा उल्लेखित न्याय निर्णय इससे संबंधित नहीं है, अतः प्रविष्टि के बिंदु पर ही अपील अस्वीकृत. So at the stage of admission itself, it was dismissed on the ground of non-deposit, and that was we had challenged before the learned tribunal.
And after page 61 is your challan showing deposit.
Yes, Milord, at page 65.
65. This fact is accepted in the counter affidavit?
Milord, they do not dispute it.
We don't dispute it. We've only said that in the tribunal's order, it was indicated that it was not brought on record. I'm not sure whether it must have been on record, Malas, before the tribunal.
Milords, we had filed a supplementary affidavit. If Milords would so say, I can bring on record the supplementary affidavit which we had filed before the tribunal.
Because the challan is there, Malas.
Challan is at page 65.
Yes, Milords.
So, total amount required was only 1,28,000.
Yes, Milords. The tax assessed is 5,11,000. So 25% we had deposited.
And where is the statement about page 65 in your writ petition and their reply?
Milords, page statement is at page. Milords, paragraph 15. If Milords would see page 12.
12.
Subparagraph notes, after the revision application was filed, the petitioner was directed to deposit the amount of 25% of the tax liability fastened upon the petitioner since the petitioner was facing recovery proceeding. Said order was passed on ITNA, pursuant whereto on 28/4 the petitioner deposited an amount of rupees 1.28 lakhs.
So this order was passed by the commercial
Tribunal,
tax
Manoj. Yes, Manoj.
Why did it not take notice of it?
Manoj, the less said is better, Manoj.
And where is the reply about this para 15?
Yes, Manoj.
It's in para 16 of the counter affidavit, where we said that it has been suitably replied in the aforesaid paragraphs.
So
Page 10, paragraph 16 minutes.
para 16.
Yes, Manoj. Of the tax assessed.
So we can send it back to the JCCT appeals now.
Yes, Manoj.
Yes, Manoj.
Or learning council for the parties.
Manoj, only one thing, Manoj.
Yes.
Manoj, the observation made at paragraph 33 at running page 92, that has to be, Manoj, clarified.
3 at 92.
Yes, Manoj, where I have been directed to deposit again 20%, that has to be clarified, Manoj.
No, that is what we will do. Otherwise, how
Yes.
will we? Petitioner is before this court as the Learned Commercial Taxes Tribunal in its impugned judgment dated 27 January 2020. Dismissed, order dated, dismissed the revision application number HZ99 of 2014, refusing to interfere in the order dated 15 July 2014 passed by the learned JCCT within bracket appeals, Hazaribagh division, Hazaribagh, whereby the appeal within bracket annexure 4 kar dijayega JCCT or commercial taxes ka annexure 7, whereby the appeal preferred by the petitioner under section 79 of the VAT Act 2005 was dismissed on the ground of non-deposit of 20%
Yes, Manoj.
of the tax assessed.
Yes.
Stop. Learned Tribunal, however, gave liberty to the petitioner to move before the appellate authority by depositing 20% of the assessed tax. And in that case, the appellate authority was asked to proceed in accordance with law. Stop. Petitioner had deposited 1,28,000, which is 25% of the assessed tax,
Yes, Manoj.
as per page 65 Challan, in terms of the interim order dated
Page 63, Manoj.
63. April 2015, passed by the Learned Tribunal in the pending revision.
Paragraph 7, Manoj.
On this deposit was made when, Mr.
Yes. Manoj, 28/4/2015.
28 April 2015. The total tax amount as per the assessment order is 5 lakh.
Manoj, 511,409.
402 or 409?
409, Manoj, 511,409.
नहीं appellate order में तो 402 लिखा हुआ है.
Given in the assessment order is 402, page 56.
402 लिखो. Assessment order is annexure 2.
Yes,
हुई
yes,
ना है?
yes. Yes, yes.
Dated
15th of March 2014 minutes.
15th March 2014.
Yes, madam.
Stop. Then counsel for the petitioner Para has submitted that the learned tribunal did not take notice of the proof of deposit of 20%, 25% of the amount of the assessed tax in terms of section 79(3) of the JVAT Act, and erroneously dismissed the revision petition. Stop. There is no question of making a fresh deposit for the petitioner to avail the appellate remedy. Stop. Therefore, a petitioner is before this has approached this court. Stop. Respondents have filed a counter affidavit. Stop. The interim order dated 8th April 2015 passed by the learned tribunal, and deposit made to Chalan at page 65 of an amount of 1,28,000 against the tax of rupees, the assessed tax of rupees 5,11,402 has not been specifically disputed. Stop. Disputed though, relying upon provisions of the section 79(3) of the JVAT Act, the respondents have taken a stand that the appeal before JCCT, within bracket appeal, could not be admitted on failure to deposit the 20% of the tax assessed. Stop. It appears that the issue has unnecessarily dragged the parties to this court simply on account of an error of record on the part of learned tribunal. Stop. In such circumstances, and the proof of deposit of 1,28,000 on the part of the petitioner, which is that is 25%.
Yes, minutes.
25% of the assessed tax
It has been approved 2015.
deposited in April 2015. The matter requires consideration by the JCCT appeals. Stop. It is accordingly remanded as such. The since sufficient time has been consumed, since the litigation has consumed sufficient time, there is no purpose in remanding the matter to the Commercial Taxes Tribunal. Stop. The No purpose would be served by remanding the matter to the learned commercial taxes tribunal when the main appeal on
Yes, ma'am.
stop. The observed tribunal rejecting the appeal on the ground of pre-deposit is clarified accordingly.
Much obliged.
Obliged, my lord.
Yes. The petition is disposed of.
Item 51, WPT number 2466 of 2021, Mr. Piyush Poddar for the petitioner, Mr. Amit Kumar for the.
Yes, my lord. In batch of cases, Mr. Milan Kanti Roy has already joined, my lord. A batch of cases which was BCCL cases.
Yes. Where is Mr. Roy?
He has joined, my lord. Okay, तो join किया.
Item 39 to 44.
How long will we wait for Mr. Roy to appear?
He has already joined according to this. He has joined right now. कहाँ फिर चलेगा क्या? Still is there, my lord.
No counter affidavit has been filed. Though counter affidavit has been filed by the Commercial Taxes Department in all these connected writ petitions, सब में फाइल किया है ना डिपार्टमेंट?
Yes. हाँ हाँ वो सब में किए हैं खाली यही JVB नहीं किए हैं.
Not filed an affidavit even after sufficient time granted by the order dated 17th February 2022. 7th February 2022. Stop. Despite revised call, no one appears on behalf of the respondent JBBNL. Stop. Clear करेंगे तब ना भाई लिस्ट में नाम. In such circumstances, we are constrained. Further 3 weeks' time is allowed to the respondent JBBNL to file counter affidavit by way of last indulgence, failing which the chairman cum managing director of the company shall have to appear in person on the next date. 1 week time thereafter is allowed to the petitioner to file reply in the respective petitions.
Yes,
Listed after 4 weeks.
BCCL matters.
इससे क्या आ रहा?
मिस्टर पोद्दार,
Yes, my lord.
आपने जो सर्टिफिकेट्स ऑफ एग्जेम्पशन प्रोड्यूस किया,
हाँ हाँ
वो सारा उसका एक्सटेंशन लेने के लिए एप्लीकेशन आपने पहली बार जून 2021 में फाइल किया, यही ना? बियॉन्ड 5 months.
Yes, but my submission is, my lord, that even if I have filed in June, but the interpretation.
जो मिस्टर पोद्दार जिस तरह से हम लोग समझना चाहते हैं वो उसका आंसर दीजिए पहले। आपके पास एग्जेम्पशन सर्टिफिकेट सबका मिल गया?
हाँ मिल गया हुजूर।
उसका एक्सटेंशन जो कराना जरूरी था, वो एक्सटेंशन का एप्लीकेशन आपने असेसमेंट ऑर्डर के बाद फाइल किया, जिसको वो रिजेक्ट कर दिया।
हाँ हाँ
यही ना है?
हाँ हाँ हुजूर।
आपका यही कहना है कि वो एक्सटेंशन का एग्जेम्पशन का सर्टिफिकेट किसी भी स्टेज में लिया जा सकता था?
हाँ सुप्रीम कोर्ट भी बोला है।
तो आपने जब ऑडिट का पैरा आपको डिस्क्लोज नहीं किया, ये आपका कहना है?
हाँ हाँ।
और शो कॉज नोटिस के बाद जो आपने सर्टिफिकेट्स फाइल किया, उसका एक्सटेंशन के लिए एप्लीकेशन क्यों नहीं दिया उस बीच में? या एक्सटेंड कर
मगर मेरा कहना है कि हम लोग सर्टिफिकेट फाइल किए which were accepted by the authority concerned and no objection was raised. Therefore, it is a deemed compliance also, my lord. And the question arises ki when I have to apply for extension, if the authority would have asked me to produce the certificate, and if I could not produce the certificate within 5 months, then I was required to apply for extension, and the notification is so vague, it does not prescribe as to upon which authority the extension is to be applied, and number two, upon which authority suo moto, if I am required to file it suo moto, then on which authority before whom I have to file the certificate. My lord, exemption notification may kindly be seen, my lord. Page 84.
Relevant what?
Relevant is 84, my lord.
84 of writ petition.
Volume 1, my lord. Part 1.
मेन रिट पिटिशन में भी है एग्जेम्पशन नोटिफिकेशन?
हाँ मेन में भी है, सेम पेज नंबर उसमें भी 84 में है।
84 में, अच्छा 84। Yes.
Yes, my lord. Page 84, item number 5 of that notification, my lord.
Yes.
It says, if the manufacturer of food preparations produces a certificate from an officer not below the rank of Deputy Secretary to the Government of India, or not below the rank of Deputy Secretary to the state government concerned, to the effect that such food preparations have been distributed free to the economically weaker sections of the society under a program duly approved by the central government or the state government concerned within 5 months from the date of clearance of such goods, or within such further period as the Deputy Commissioner of Central Excise or the Assistant Commissioner of Central Excise, as the case may be, having jurisdiction may allow in this regard. My lord, this says that produces a certificate. The question is whether I am required, according to the language employed in this notification, whether I am required to produce suo moto or having been asked by any of the authorities to produce, because the word used in this notification at the latter stage, whenever it was required that I should furnish it, the word is used is furnish, file, submit. But so far this para 5 is concerned, produces, and produces always presupposes that when a person is asked to produce, and if he fails to produce, then the matter would be different. But here I am not required to produce this suo moto. That interpretation is required to be done. So far this notification notification is concerned, my lord, from the latter part of this notification, कहाँ जहाँ पर produce लिखा हुआ है. Then my lord, page 92 में kindly be seen. इसी notification का 39.
A person who is claiming exemption is the person who is required to produce proof under that notification for page 92. Yes.
Notification starts from page 39, my lord.
39.
उसके बाद पेज 41 में शो करेगा कि फूड फ्रूट प्रिपरेशन का आइटम नंबर 21. पेज 41.
Page 41.
Yes, my lord. Serial number 21. Food preparations put up in unit containers and intended for free distribution to economically weaker sections of the society under a program duly approved by the central government or any state government. Tax is nil.
Very well. Mr. Amit Kumar.
And condition उसमें लिखा हुआ है 5.
Yes, Lordship. Sorry, my voice is today I am suffering from cold, Lordship. So my voice is not very clear, Lordship.
No, it's quite clear. Don't worry. We want to know that if the request for extension for time in for submitting that exemption certificate is made before the appellate authority, can he not entertain that request and accept those exemption certificates? You say that since the adjudicating authority had become functus officio, therefore he could not have granted extension.
Yes, Lord.
But if otherwise, the appellate authority is in season of the matter and appeal being a continuation of the main suit, such a request is made before the appellate authority, can he not consider that request a genuine request and appreciate the reason for the delay? The delay, had it been on the part of the petitioner, things would have been different. But if the delay was on the part of the state government, then what reason or logic prevails to penalize the assessee for that? Maybe some procedural error that he could not seek extension. But
the notification, the time limit is of 5 months. So
whether there is a power to extend or not?
Yes, there is a provision for extension of time given to the
where is
SO Lordship.
84.
Where my learned senior friend has, in the first instance, has.
Yes. Page 84, 5.
Yes, Lordship, 5.
Period.
Yes, 5 months from the date of clearance put or within such further period as the Deputy Commissioner of Central Excise or the Assistant Commissioner of Central Excise may case may be given having jurisdiction may allow in this regard, Lordship.
So, in this case, according to you, it was respondent number 1 or 2?
Yes, Lordship. They should have applied for extension before respondent number 1, before the adjudication proceeding has been initiated, Lordship.
Respondent number 1 means Assistant Commissioner.
Yes, Lordship.
Who is the assessment officer?
In this case, the order in original has been passed by the Commissioner, Lordship. Respondent number 2.
3.
Sorry, 3, Lordship.
Achha, 3. Commissioner Audit.
Commissioner Audit has issued the show cause notice, Lordship, because and thereafter the adjudication has been done by the respondent number 2, Principal Commissioner.
So the extension of time to submit certificate could have been done by an authority lower than the principal commissioner.
Yes, Lordship, as per the notification by the Assistant Commissioner.
The appeal against the OIO will lie against the before the SESTAT now.
Yes, Lord. And they can file it till 31st of May, Lord.
That is there. ये जब तक सेटिस्फाइड नहीं होगा तब तक तो उसका एक्सटेंशन से भी कुछ नहीं होगा. तो फिर question.
My lord, may I kindly see page number 241.
Mr. Poddar. Mr. Poddar, ये जो आप exemption certificate can be submitted at even at the appellate stage or the tribunal stage, इसके लिए आप कौन सा judgment rely कर रहे हैं सुप्रीम कोर्ट का?
May I submit one thing, Lordship? This
Yes, my lord. Annex 9 में kindly be seen, my lord. Annex 9 at page 447. तो रीट में भी वही पेज है और कंपाइलेशन में भी वही सेम पेज है. फोर फोर एट उसमें है और 447 उसमें है.
ये जजमेंट तो पेज 133 आपके कंपाइलेशन में भी है.
हाँ, कंपाइलेशन में भी है, पेज 448 में है और रिट पिटीशन में भी है 447 एनेक्सर 9 में.
हाँ, तो इसका जो थर्ड पैराग्राफ है,
इसका ट्रिब्यूनल का ऑर्डर भी इसके साथ लगा हुआ है नीचे में. ये जो सुप्रीम कोर्ट का ऑर्डर
इसका थर्ड पैराग्राफ में पढ़ने से ये लगता है कि एसएससी ने ट्रिब्यूनल के सामने सारा सर्टिफिकेट प्रोड्यूस किया, ट्रिब्यूनल ने अपने इम्प्यून्ड ऑर्डर में लिखा भी, लेकिन उसको उसका एग्जेम्पशन का बेनिफिट नहीं दिया.
हाँ,
तो हमारा कहना ये है
बोले कि अगर
नहीं, हमारा कहना ये है कि आप ट्रिब्यूनल में नहीं गए हैं, आप भी ट्रिब्यूनल में ये सारे सर्टिफिकेट को शो करके एग्जेम्पशन का क्लेम प्रेस कर सकते हैं कि हमारे तरफ से सिर्फ यही गलती हुई है कि हमने एक्सटेंशन का रिक्वेस्ट टाइम पे नहीं किया क्योंकि वो नोटिफिकेशन वेग है. तो एग्जेम्पशन यदि इसी स्टेज में भी मिल सकता है तो ट्राइब्यूनल कैन आल्सो कंसीडर दैट.
नहीं, इसके पहले उन्होंने एक बार
क्या एक कुमार व्हाट आर यू सेइंग?
यस लॉर्डशिप, ये जो नोटिफिकेशन है as per page 41 lordship, item 21, जहाँ पर दिया हुआ है कि page 41 of it.
हाँ, 21.
Yes, lordship. Lordship, you see 1901, food preparation put up in the unit container are intended for free distribution to an economically weaker section of the society under a program duly approved by the central government or any state government. Then the next para nil, and then next column is where it is written para 5. That means kindly turn to page 40. The next column is condition number, lordship.
Page 40.
Yes, lordship. Just previous page.
हाँ, नहीं वो तो समझ रहे हैं. तो वो पैरा 5 is at page 84.
Yes, para 5 is page 84. This is the condition for getting the benefit of exemption law.
ठीक है, तो कोई अप्लाई फॉर एक्सटेंशन के लिए तो कोई टाइम लिमिट नहीं दिया हुआ है. एक्सटेंशन हो सकता है फॉर फर्दर पीरियड, इसी का एक राइडर दिया हुआ है.
यस यस सर. ये
आपका ग्राउंड ये है कि ओआईओ फाइल करने ऑर्डर होने के बाद इन्होंने एक्सटेंशन का दिया, तो वो कैसे करते हैं?
जी जी,
वो जो जेवीएस फूड के जजमेंट में है कि ट्राइब्यूनल के स्टेज में भी वो प्रोड्यूस किए थे, ट्राइब्यूनल डिस्कस किया. अब एक ही चीज इसमें नहीं क्लियर हो रहा है कि वो एक्सटेंशन का एप्लीकेशन वही सेम नोटिफिकेशन था या कोई दूसरा नोटिफिकेशन था ना. ये दूसरा नोटिफिकेशन होगा क्योंकि पीरियड 2000 से 2001 था ये.
क्योंकि ये ओरिजिनल में भी इसको डिस्कस किए हैं वो जेवीएम फूड को जो. और पैरा काउंटर में भी है, इसमें पेज 95 में दिया हुआ है जो.
नहीं, ये ऑर्डर में किस पेज में डिस्कस?
ऑर्डर में है
357.
ये जेवीएम फूड का डिस्कशन किए हैं D50 में है जो 350. हाँ, D for Delhi 50 में.
एक पैराग्राफ नंबरिंग है डी सीसी जयपुर जेबीएस
इसका पैंट का जो थोड़ा सा डिफरेंट है प्रेजेंटेशन।
हाँ वही कैबिनेट करना इनको एक्सटेंशन इसमें कंडीशन नहीं था जेबीएस फूड में और ये दूसरी जगह से ले लिए थे सर्टिफिकेट वर्ल्ड फूड प्रोग्राम का गवर्नमेंट ऑफ झारखंड से नहीं
कोई सर्टिफिकेट मिला नहीं और जितना मिला उसका मिल चुका है, जितना मिला उसको मिल चुका है।
People did not decide the issue whether certificate was produced in time and whether extension was sought. इसमें उसी में ये माल कहा जा रहा है इसके थोड़ा सा लिबरल हो जाएगा तो वो है इतना हम लोग का चाहिए 21 पे 41 फिर ये लगना चाहिए चैप्टर दीजिए
My lord, may kindly look into page 240 of the compilation, my lord, wherein I have, in reply to their Soko's notice,
240
yes, 240. This is the reply given by me to the Soko's notice, my lord. Soko's notice, and I filed the reply. Page 240. Certificate has not been submitted within the prescribed period. This was the allegation. And what I have stated before the authority concerned, it is humbly submitted that in the terms of conditions mentioned in the exemption notification itself, the said period of 5 months is extendable and no maximum time limit has been prescribed for the said extension. Hence, it is submitted that since the certificates have now been submitted, the condition mentioned in exemption notification have been duly fulfilled. Honorable Supreme Court of India, ये इसी केस का उसके बाद हुजूर 241 8.8 without prejudice to the above, it is also pertinent to highlight that the SSC had undertaken all possible measures to obtain the said certificate within the prescribed time. This is evident from the various applications and letters written by the noticee to the Department of Women, Child Development and Security requesting the certificates from time to time. Copies of said letters are annexed herewith and marked as Annexure 3. Hence, the delay in submission of certificate, if any, is not attributable to the SSC. 8.9. Without prejudice to the above, it is humbly submitted that as discussed above, in the terms of the conditions mentioned in exemption notification itself, the said period of 5 months is extendable and no maximum time limit has been prescribed for the said extension. Hence, it is submitted that the said delay is condonable by the Deputy Commissioner of Central Excise or the Assistant Commissioner of Central Excise, as the case may be, having jurisdiction in this regard. It is submitted that even if the earlier request of condonation of delay and submission of certificates before the jurisdictional officer or audit team is not considered, even then this reply to so-called notice communication may kindly be considered as an application for condonation of delay in submission of certificate as required under the exemption notification. It is
Yes.
It is also submitted that your good officer is the office authority under whose jurisdiction the Deputy Commissioner of Central Excise or the Assistant Commissioner of Central Excise, as the case may be, having jurisdiction in this regard. Hence, this request for condonation without prejudice to the above grounds is being made before your goods office, and it is prayed that it may be held that with the submission of the requisite certificates, the conditions prescribed in the exemption notification are duly complied with. Moreover, it is requested that the concerned jurisdictional officer is also directed to report rule compliance of the said condition.
Very well. Mr. Amit Kumar, you have to add anything?
Lordship, the judgment which my learned friend has relied is not applicable. That I have shown in the para D50, Lordship. And all the relevant points which have been raised by the petitioner has been duly been answered by the in the order in the original, Lordship.
Yes, yes.
And our primary objection in regard to the Lordship, the alternative remedy, Lordship.
This is fair. By Mr. Amit Kumar,
Lordship.
respondent number 2 has passed the assessment order only because of the total value of the tax amount due.
Yes, Lordship.
And what argument do you have on the pre-consultation notice?
On the pre-consultation, because the notification says that before issuing of show cause, Lordship, the adjudicating officer commissioner has held that since a show cause notice has been issued by the audit commissioner audit, so there was no occasion for him to issue pre-show cause notice, Lord, pre-show cause consultation. Yes, there is that point also, and it's a order in original, Lordship.
My lord, after issuance of so cause notice, my lord, I have duly filed an objection that please allow pre-consultation as provided under the master notification, and that master notification is mandatory in character, my lord. That has already been held by Delhi High Court, my lord. Paragraph 16 I may be allowed to read it, my lord. That is reported in 2019 Supreme Court cases online Delhi 8437. वो नहीं है उसमें, हुजूर, हम खाली पढ़ देते हैं, दे देंगे. Paragraph 16. 2019 SCC Online Delhi 8437. Amadeus India Private Limited versus Principal Commissioner. 2019 SCC Online Delhi 8437. The party's name is Amadeus India Private Limited versus Principal Commissioner.
This is of Delhi High Court.
Yes. Delhi High Court, my lord.
Page number 11.
Page number 8437.
8437. Okay.
So for this lordship, the pre-show cause notice issue is concerned lordship. The para D5 to D14, the commissioner has dealt this issue with lordship in order in original lordship.
This Delhi High Court judgment is by Justice Murlidhar.
Yes, my lord.
Very well, we have.
Yes, yes, Honorable Mr. Murlidhar and Pratik Jalan.
So, at which paragraph that pre-consultation?
Yes, paragraph 16, my lord.
And Mr. Amit Kumar, in the OIO, at which paragraph this pre-consultation?
Yes, lordship. D5 to D14. We have also dealt in para 17 of counter affidavit.
D5 to D15, para 17 of CA.
And my lord, section 37 of Central Excise Act, section 37B of Central Excise Act also makes it very clear that the circulars issued by the board will be binding.
How much is the pre-deposit before the sestet? 7.5%.
Yes, 7.5.
First year.
And my lord, section 37B of the Central Excise Act may kindly be looked into, my lord.
Which?
Section 37 capital B of Central Excise Act, my lord.
Yes.
Instructions to Central Excise officers. The Central Board of Excise and Customs constituted under the Central Board of Revenue Act such and such may, if it considers it necessary or expedient so to do, for the purpose of uniformity in the classification of excisable goods or with respect to levy of duties of excise on such goods or for implementation of any other provisions of this Act, issue such orders, instructions and directions to the Central Excise officers as may deem fit, and such officer and all other persons employed in the execution of this Act shall observe and follow such orders, instructions and direction of the said board. Therefore, any circular issued by the board is binding upon the authorities, my lord.
Yes, that is not a disputed position in law.
And my lord, then my lord, page 312 may kindly be seen, my lord. Page 312.
312.
हाँ, इसमें क्या बोलते हैं?
312 of writ petition.
हाँ, ये 312 of compilation, writ petition में यही पेज है क्या? सेम पेज है. सेम. हाँ, 312 सेम पेज में लॉर्ड, कंपाइलेशन में भी और रिट में भी, जहाँ पर ये डील किए हैं प्री कंसल्टेशन के लिए, जहाँ पर डील किया गया है इम्प्यूग्ड ऑर्डर में. D5 पैराग्राफ D5. Yes. Further, I find that the noticee has given maximum emphasis on pre-show cause consultation. the noticee has submitted that the said SCN is without jurisdiction, illegal and arbitrary because no pre-consultation has been given to them in terms of CBEC Master Circular dated 10/3/17. I have very profoundly examined the facts on record vis-a-vis the submission made by the noticee. Provision given at paragraph 5 in the master circular about which the noticee is contending provides that. And then Millard D6 ma'am, on perusal of above circular, it is found that as per para 5.0 of said circular, in case of offense related to SCN, such pre-consultation is not required. यहाँ पर offense कहाँ है हुजूर? Where is the question of offense? In case of offense related SCN will not apply. He says, he interprets this master circular to the effect that on perusal of above circular it is found that as per para 5.0 the said circular, in case of offense related SCN, such precondition is not required. Meaning thereby कि ये मान रहे हैं कि हमारा केस ऑफेंस रिलेटेड है, ऐसा तो कहीं पर एलिगेशन नहीं है, कुछ नहीं है.
नहीं, उसके बाद 2020 का सर्कुलर
Suppression, willful suppression of act. Wait payment of central excise duty.
Anyway.
And Milord, कब कब हम प्रोड्यूस किए हैं, एक बार हमारा जो नोट्स है जो चार्ट जो है उसके नीचे देखा जाए सप्रेशन कैसे है, देखा जाए पेज 4 नोट जो हम लिखे हैं, इसको हम जरा पढ़ देते हैं. पेज 4 हाँ, जो रिटर्न और सबमिशन जो फाइल किए हैं आफ्टर द चार्ट, जिसमें दिए कि कब अप्लाई किया, कब हमको मिला. पिटिशनर प्रोड्यूस एग्जाम्पशन सर्टिफिकेट मिला मुझे.
हाँ, मिल गया.
हाँ, हम पढ़ रहे हैं. Petitioner produced the exemption certificate before the audit team during the course of audit from 18/4/17 to 24/17. 17 महीने दिए हैं for the period 2014 and 2015. 6 reference audit observation in Annexer 25 at page number 113 of rejoinder, Annexer 25 at page 623 of volume 1 part 2 of compilation, and its reply dated 21/7/2017 in Annexer 26 at page 118 of rejoinder, Annexer 26 at page 698 of volume 1 part 2 of compilation. उसके बाद exemption certificate for the period from April 16 to June 17 was produced by letter dated 23/5/2019 before the authority, Annexer 29 series at page 128 to 131 of the rejoinder, Annexer 29 series at page 708 of volume 1 part 2 of compilation. All exemption certificates were also produced during the course of adjudication proceeding by before the adjudicating authority. Annexer 37 at page 147 to 156 of rejoinder, Annexer 37 at page 723 of volume 1 part 1 of compilation. Therefore, my lord, now from a perusal aforesaid table, from a perusal aforesaid table, it will be clear that petitioner had applied for issuance of requisite certificates well within period of limitation as provided under exemption notification issued by central government, but the same were issued by the state government belatedly. Therefore, it was impossible for the petitioner to produce such certificates within 5 months as prescribed in the above exemption certificate. Therefore, doctrine of impossibility is applicable in this case as held by Honorable Supreme Court. Reliance is placed on a case of Honorable Supreme Court in the case of Madhya Pradesh versus Narmada Bachao Andolan, reported in 2011, 7 SSC 629, para 39 and 40. My lord, I may be permitted to read paragraph 39 and 40. Yeah. Doctrine of impossibility. This is reported in my lord 2011, 7 SSC 639. Para 39.
Justice S.P. Sinha. 2005 13 SCC 38789 na.
2011 volume 8 SCC 7 SCC sorry 7 SCC 639 पैराग्राफ 39 and 40 मिला बहुत बड़ा जजमेंट है
ये तो आपके कंपाइलेशन में नहीं है
नहीं उसमें नहीं है
वो फिर अभी डोंट
हम पढ़ देते हैं हुजूर पैराग्राफ 39 and 40 डॉक्ट्रिन ऑफ इम्पॉसिबिलिटी
वेरी वेल
अच्छा हम इस दो पैराग्राफ को हुजूर पढ़ देते हैं द कोर्ट
yes
may I read the court has to consider and understand the scope of application of the doctrine of less non cogit and impossibilia. The law does not compel a man to do what he cannot possibly perform. Impossibilia, the law does not expect a party to do the impossible and such in qualified sense that there is a necessity or invincible disability to perform the mandatory part of the law or to forbear the prohibitory. The maxima are akin to maxim of Roman such and such, which is derived from common sense and natural equity and has been adopted and applied in law from time immemorial. Therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested had no control, like an act of God, the circumstances will be taken as a valid excuse. Para 40. Thus, where the law creates a duty to charge, a duty or charge, and the party is disabled to perform it without any fault on his part and has no control over it, the law will in general excuse him. Even in such a circumstance, the statutory provision is not denuded of its mandatory character because of supervening impossibility caused therein. Without under the notification, otherwise required to produce the certificate within 5 months.
very well that was in a different context of Narmada Bachao Andolan here the impossibility
एक चीज और देखा जाए हुजूर ये invocation of extended period is also wrong. Milord, page 652 of my compilation में काले volume 1 part 2.
that we won't look, Mr. for that. That you are treating us as an appellate authority. That we will not. आप फाइल कर सकते हैं, but how much we will entertain, that is up to us. लिखिए. We have heard learned senior counsel for the petitioner, Shabiran Podar, and assisted by Mr. Deepak Kumar Sinha and Mr. Amit Kumar for the respondent department. So the case for orders on 6th May 2022. Wait, there are इस पुटिंग तो बना हुआ है इसका प्लास्टिक है उसमें yes ये फ्राइडे को इस ऑर्डर्स के लिए हम लोग का बेंच
Item 54. WPT number 1719 of 2022. Mr. Sumit Garodia for the petitioner. Mr. Prasant Pallam, Mr. P.S. Pati for the rest.
My lord, I am led by Mr. Tarun Gulati in this matter, my lord.
Yes. Challenge is to a circular. Should we hear this matter, because the question of ultra-virus vis-a-vis the Act and the rules is concerned?
It's only the circular, my lord, that is your lordship's jurisdiction. Sir Tarun sir, you are not audible. Still not audible, sir.
Who is for the respondents?
Well, the respondent is the Union of India.
Seems like this is coming up for the first time, Lord. We'll also need to seek instructions in this matter, Lord.
You are for the Union of India. Are you also appealing for the CGST authorities?
No, Milord. We are not appearing for the CGST authorities, Milord, because the circular, Milord, which has been challenged, Milord, that is at page number 76, Milord, and extra 6.
Circular is of CBDT.
Milord, that is of CBDT, Milord.
CBIC, sorry, CBIC.
CBIC, Milord.
You are representing CBIC, respondent number 2.
Milord, that is the instruction, Milord, that we will be appearing on behalf of CBIC, Milord.
So 1 and 2 you will be appearing.
My Lord.
3, 4, 5 and 6. Mr. Pati will be appearing.
Yes, Your Lordship. Yes, Your Lordship. His name is appearing. He'll be appearing on behalf of CGST. Lordship, I'll just inform him to join.
What is the condition which is under challenge, Mr. Garodia?
Yes. Well, may kindly come to the circular, paragraph 47 of that circular, the next 6.
Page 91, Milord.
Page 91.
Malord, I may just explain in very brief, Malord, what happens.
Yes.
Malord, when we export the goods.
Malord, am I audible now?
Yes, yes.
I'm so sorry, Malord, there was some problem in the audio earlier.
Yes.
Malord, if your Lordship sees the impugned circular for a minute, Malord, at page 76.
Yes.
Malord, what we are challenging is only one para of this circular, which is para 47.
Yes.
And Malord, may I just give a brief context before your Lordship reads this para 47? Malord, we are a steel manufacturing company, and we, Malord, import coal as well as buy it from domestic producers. And we, Malord, pay compensation cess on the purchases. On our output side, Malord, there is no compensation cess which is leviable. So this gets accumulated as input tax credit, Burma and other countries. On export, Malord, whatever is the accumulation of the ITC is available to me as refund under section 54 of the CGST Act, read with rule 89.4, Malord, which gives a formula. Now, Malord, in applying the formula, what happens is that at the time that the goods, my output, Malord, leaves the factory, the exact rate of at which I will finally sell to my the person outside the country is not known. So I raise invoices at cost. And ultimately, when the goods reach the port, or my lord, if it is by road, when they cross the borders, the final invoices are generated on the basis of the value which is determined at that stage, as well as the foreign exchange, my lord, rate which is available at that date. So when I filed my GSTR 3B returns, my lord, the factory invoices, my lord, that rate is given in the GSTR 3. But there is another report, my lord, called the GSTR 1, which contemplates that if there is a variation, then you can amend it in in chart 9 of that GSTR 1, which I have done. Now, in applying the my lord, refund, there is a formula under 89.5 where, my lord, total accumulation of ITC into export turnover upon total turnover. They have proportionated so that whatever the accumulation is in relation to the export is available to me as refund. Now, in doing that, my lord, what they do is that they take the lower value, which is my cost value, which I had, my lord, done. And the impugned circular, why we have challenged it, why they say, is because it says you take the lower of the two values. There is no such, my lord, mandate in the act. Whatever is the correct value, you have to take. And once I have amended my GSTR 1 para 9, and I put the correct value on record, where is the question of taking lower of the two values? That's the short point, my lord. There is no such prescription under the act, and therefore this circular, my lord, goes completely beyond the act. And the authorities were, my lord, applying it. The other part is, my lord, that under section 5, subsection 4, an appellate authority cannot discharge the functions of a, my lord, central GST officer. And therefore, section 168, under which the circular is issued, cannot, my lord, bind an appellate authority. My lord, in Orient, Supreme Court has also said it, and many other judgments, to say that they can't, my lord, otherwise what's the purpose of an appellate authority, my lord, if they are not independent? My lord, the appellate authority considered itself bound by this circular, which has no, my lord, statutory force, and, my lord, rejects my refund to this extent, to say that I'll apply the lower of the two values. And a peculiar, my lord, finding to say that he agrees that the value in the GSTR 3B is not the transaction value. But he says, I need not determine it. I need not go by it. And the most peculiar thing is, my lord, in the numerator, he takes the lower value. In the denominator, where it's total turnover, he takes the correct value. So, my lord, it's a completely arbitrary manner in which my lord, he has rejected my refund. And this is the reason why, my lord, we are constrained to challenge this para. Now, my lord, kindly have para 47 in this slide at page 91.
Yes.
My lord, it has, if your lordship sees page 91, para 47, it has also been brought to the notice of the board that in certain cases where the refund of unutilized input credit on account of export of goods is claimed, and the value declared in the tax invoice is different from the export value declared in the corresponding shipping bill under the Customs Act, refunds are not being processed. So this was the context, my lord, that they were not processing it at all. The matter has been examined and it has been clarified that zero-rated supply of goods is effected under the provisions of the GST law. Supply invoice issued under Rule 46 of the CGST rules. The value recorded in the GST invoice should normally be the transaction value as determined under Section 15 of the CGST Act, right, with the rules made thereunder. The same transaction value should normally be recorded in the corresponding shipping bill or the bill of export. During the process of refund claim, the value of goods declared in the GST invoice and the value in the corresponding shipping bill or bill of export should be examined, and the lower of the two values should be taken into account while calculating the eligible amount of refund. Well, there is no such, there can be no such statutory prescription at all. How can you take lower? You have to take the correct value. And if the value has been corrected in my GSTR 1, where is the question of, my lord, applying this?
The rectification in GSTR 3.
GSTR 1, my lord, I have rectified it. And if your lordship just sees, my lord, for a minute, in GSTR 1, my lord, kindly have for a minute, my lord, page, my lord, serial number 8, instructions, my lord, in the GSTR 1.
Yes.
Page 17, sir.
Page 17. My lord, that itself contemplates this situation, and it says that before claiming the refund, you must amend it, you must put the correct shipping bill values. My lord, kindly see page 17.
Yes.
This is, my lord, instructions given for the purpose of filing GSTR1. Table 6, my lord, in the middle of the page, the quote is there, my lord. Table 6 needs to capture information about shipping bill and its date. However, the shipping bill details are not available. Table 6 will accept the information. The same cannot be updated through submission of information in relation to amendment, Table 9 in the tax period, in which the details are available, but before claiming any refund repaid related to the said invoice. So you must do it before claiming refund of the said invoice. The detail of shipping bill shall be furnished in 13 digits, capturing port code followed by the number of the shipping bill. So my period, my lord, relates to January and February of 2019. By the time, my lord, I got the information, it was September. I amended it, my lord, in September, and that I put on record, my lord, as an extra 4, page 66.
Yes.
So, my lord, in this light, once I know the correct value, and what you are doing is you are creating a proportion to see what is my actual export turnover. So my actual export turnover, my lord, is what I have finally, and I have not received all the foreign exchange from all those people to whom I have exported. That value tallies with it. My Companies Act, my lord, I am reporting it as the correct turnover. In income tax, I am reporting it as the correct turnover. My books of account reflect the same turnover. How can, my lord, they can take arbitrary values like this? And why lower? Where, my lord, my invoice value was higher, the shipping bill value. How can that be done, my lord? That's the grievance, my lord, that we have.
That chart is at page
These
28.
these clarifications have been issued on the claim for refunds in view of certain issues which have been discussed
Correct.
under 43 of the same circular.
Yes, my lord.
So, which issue basically, the issue at A perhaps applies
My lord,
to the...
yes, they said that, my lord, where there is a difference, my lord, in para 47 itself, it's clear the context in which it was issued, that, my lord, where there was a difference in the shipping bill value and the invoice value, if your lordship sees the first 4 lines of para 47,
Yes.
claims were not being processed at all. So this is in terms of some kind of a facilitation that they are granting, but in that granting that facilitation, lay down a, my lord, a prescription to say that you take the lower of the two values. Our contention is, my lord, that if the correct value is available, then where is the question of taking a lower value? You take the correct value as amended by me in my GSTR1.
What used to be the reason for giving a different value in the tax invoice at
My
the
lord, I
time of...
explained it in great detail, my lord. If your lordship sees at page 117 in my reply, which I filed, my lord, before the authority, my lord, I explained to him that, my lord, there is a timing difference. When the goods leave, my lord, leave the factory and when they go to the port or to the border, there is a timing difference. At that stage, my lord, these are commodities which, my lord, daily rates differ and exchange rates also differ. So on both these accounts, my lord, the final rate when the goods are loaded at port, that will be the final rate. So because I don't know the rate at the time that the goods are exiting from the factory, and I must raise a GST invoice at that stage. Otherwise, my lord, there is no implication of a GST invoice because exports are duty free, my lord. They are at nil rated, they are 0 rated. So there is no such implication as far as it's only a reporting. What I am entitled to is a refund of my accumulated ITC, and in that, my lord, there is a formula to say that I will not grant you the full ITC refund, full accumulation. I will only grant you the refund which is in proportion to your total export turnover as a proportion to your total turnover. So if I have 100 accumulation and my export turnover is 50 and my other turnover is 50, they will grant me, my lord, only 50% because proportion of export turnover over total turnover is 50%. Now, in calculating that proportion, they are not taking 50, they are taking 40 because that was the value declared at the time of when the goods exited from the factory. Problem. So my proportion comes down, and to that extent, my lord, the refund comes down. So I've been granted 3.5 crores and I've been denied 1 crore 12 lakhs.
The reason could be that the invoice at the time of exiting the boundary, the rate at which the invoice is raised at the time of exiting the boundary of the country may not be properly verifiable by the authorities.
No, Lord. There's no difficulty on that. In fact, the finding of the authorities is that it is not in dispute that that is the correct, your GSTR1 value is the correct transaction value. That's a clear finding.
Where is that?
My lord, if your lordship sees page 165 in the appellate order,
Yes.
para 7, if your lordships were to see the last 7-8 lines, my lord, the word starting the appellant.
Yes.
The appellant, however, in the submission claimed that this difference of zero rated turnovers accrued due to the conversion rate of foreign exchange currency value into Indian rupee when sales with the foreign customers were agreed at port, which was substantially different when the goods were supplied from the plant to port for export purpose on invoices usually raised at cost price. Well, this is what I explained to you, Lordship.
Yes.
These invoices were values are accordingly reflected in the monthly GSTR1 returns, and the correct value in these cases they got revised as required in table 9A of GSTR1 during the month September. The dispute is not about the correctness of the revised value of zero rated reflected in table 9 of the GSTR1. Hence, sanctioning authority is right in done. Well, the sequitur doesn't follow from that. In fact, I have received the foreign exchange. It is reflected in my books of accounts as also in the GSTR1 value. I raise the commercial invoice at the true value. So that can't be, it's verifiable. And thereafter, my lord, if your lordship sees the findings, he simply applies, my lord, at page 168, para 11, this para 47 of the circular and disallows the refund. And very peculiar finding in para 12 of the order at page 169, saying that I need not determine the transaction value. If you don't determine the transaction value, how will you accept my turnover?
They are saying that contrary to the rules, the invoices issued at factory gate were not having the real transaction value of the supplied goods, but reflected only a customary entry therein.
Because it's not known at that stage and it can't be therefore the correct value. And these are not commercial issues. These authorities have also to apply their mind according to business practices which are prevalent. Businesses can't be done in the silos that they want us to conduct business, unfortunately. They are trying to straitjacket a business practice which is not possible. Kindly see, my lord, at page 168, the only reason given, not that the statute says so, the only reason given at page 168, my lord, para 11, middle of the para, is this para 47 of the circular.
In that case, the variation could be on the lesser side also when you...
Yes, and they say, so when the variation is lesser side, they take the lower value again because of the circular. How can that be, my lord? So to that extent, your lordships are right that accepting the shipping bill value is not their problem. They say lower of the two. In some cases, they have accepted the shipping bill value.
Page 28, sir, we have given that illustration.
Absolutely. In some cases, my lord, there is decrease. In some cases, there is no change, and in some cases, there is an increase.
And this correction in the column 9A of GSTR1 is done at what length of time?
But in September we did it prior to filing of the refund application. Our refund application is 22/12/2020, and in the September GSTR1 which was filed, my lord, we corrected it. And that's what, my lord, is the requirement, that before filing of the refund, you correct it so that it becomes part of the record.
Yes, you file counter affidavit.
My lord.
Mr. Parsilan appears learned senior counsel, Mr. Tarun Gulati, assisted by Mr. Govind Garodia, appears for the petitioner. Stop. Then counsel for the petitioner has questioned the validity of para 47 of the circular dated number so and so dated 18 November 2019 annexure 6 issued by respondent number 2, which stipulates that while processing refund claims in excess of exports, the lower of the value indicated in the tax invoice in the shipping bill should be taken into account, as they are contrary to the provisions of the CGST Act and the rules. Stop. Then counsel for the appellant, petitioner submits that the entry in the GSTR1 at the time of the goods being transported from the factory are at a ऐसे लिखे some of the turnover, some of the goods produced by the petitioner company are exported at zero rated supply of goods, in respect of which the petitioner pays compensation cess, which remains unutilized in its credit ledger, for which refund claim has been made. The same has been denied, relying upon para 47 of the circular dated 18 November 2019. Even by up to the appellate stage, though the appellate authority has taken note that the invoice values reflected in monthly GSTR1 returns got revised as required in Table 9A of GSTR1 during the month of September 2019. So there is no dispute about the correctness revised value of zero rated supply reflected in Table 9 of GSTR1. So, however, the appellate authority went on to uphold the order granting refund on the basis of the value of the transaction reflected in the invoices raised at time of movement of the goods from the factory. The authorities have failed to take into consideration that
नॉर्मली होना चाहिए मतलब कि आप एक्सेप्टिंग की एक ही रहेगा value recorded in GST should normally be in transaction value. So they are admitting the fact that अलग भी ले सकता है तो यहाँ पे why reason
क्या लिखे
However, the appellate authority went on to uphold the order granting refund on the basis of the movement of the goods from the factory. The authorities have failed to take into consideration the value of the transaction reflected in the invoices and the time form.
The authorities have taken the lower of the two values, that is the value of the goods declared in the GST invoice and the value in the corresponding shipping bill/bill of export while calculating the eligible amount of refund. Stop. The compensation cess is
Malad, in terms of section 8.2 of the GST compensation to states act 2017, right, with the schedule there too, it is paid, Malad, at a specific rate. It is available as ITC under section 16 of the GST Act.
no at the GST invoice at the declared at the time of the goods being moved from the factory or the corresponding.
No, Malad, this is all our purchases. This is a cess which is available on coal. We, my lord, use that coal and manufacture steel. On the output side, on steel, there is no GST cess. It's only on coal.
Very good. Zero rate. Learned Counsel for the Respondent Union of India, Mr. Parth Chalan, AC2, ASGI, on behalf of the respondent number 1 and 2, while Mr. PSP appears for respondent number 3, 2, 5, 6. And counsel for the respondents pray for and are allowed 4 weeks time to file counter affidavit. 2 weeks time thereafter is allowed to then counsel for the petitioner to file reply if necessary. Stop. This is the case after 6 weeks.
Malad, Mittal was also with me, Malad.
Mr. Salona Mittal.
Assisted by.
Can we appear with this?
Yes, yes.
Obliged, my lord. Deeply obliged.
Deeply obliged, my lord.
Yes.